Yes. Though we know Rti Act is of 2005, but when you see the genesis of the RTI, you'll be surprised that RTI is applicable in Sweden since 1766. We got it in 2005. In fact, Thomas Jefferson, who was the third president of USA and who was the architect of drafting of Declaration of Independence, he had used a very right one to define. Information is the currency of democracy. And that's the truth which will come out over the period when we'll go through the entire act and see how it is. So, precisely, definitely the UN Declaration also came in, which was adopted in 1948, which also said that seeking information and idea is your right. But in India, the first time when you see information was actually used was in a matter which is a celebrated matter, which we all know led to the emergency of India. That was Uttar Pradesh versus Raj Narayan's case, 1975, Supreme Court. So in this case, what happened? Now the whole thing was that the incumbent prime minister at that time had used the official machinery for her election process. And there was a challenge made in Allahabad High Court with regard to the fact that this was a misuse and which is not in conformity with the electoral norms. Now, to get this information, at that time, Section 123 of the Evidence Act was used, which says that none of the unpublished document can be used by anyone unless until it has been issued by a competent officer or the government authority. Now, that's how the Blue Book was issued, which contained the security guidelines of the Prime Minister of India in travel and so on and so forth. So that's the first time you see this use. Definitely, this is a landmark judgment. I'm sure most of law students would know that what happened in Indira Gandhi versus Raj Narayan's case on 25th June 1976. The Supreme Court gave partial stay. Justice from Kerala, how I can missed him, the famous Justice Iyer, Krishna Iyer, gave the partial stay that Indira Gandhi will function as the Prime Minister, but she will not discharge the duty in the Parliament till the opening or reopening of the Supreme Court, which was effectively a complete stay because Parliament was not in session and Supreme Court would have opened before. But 26th June, we have the emergency in India. So very landmark judgment in which we use the information to unsettle an elected personality. Second time, when it was used, and where again Supreme Court affirmed that the right to information is very, very important. What we call, as a lawyer, when you grow up, you will read judge's case number 1, judge's case number 2, and judge's case number 3. This is judge's case number 1. In which case, what happened? In 1980, there was 8 chief justices of the High Court was transferred by the government after taking the concurrence of the Chief Justice of India, at that time, Justice Chandrachud. Now, this was challenged by a very celebrated lawyer, S.P. Gupta. Unfortunately, we lost him this month only. So, S.P. Gupta challenged this in the Supreme Court of India. And I'm not going to the detailed part of it, he sought in that an information which was the communication between the Law Minister, the Chief and Chief Justice of Delhi High Court. Definitely the government had not provided, and government took the shelter of Article 74 of the Constitution of India. But Justice Bhagwati, writing the judgment, said that this information is not a privileged communication and hence has to be provided. So in India also, if you see, the there has been movement for RTI. It is not the solitary incident I'm just quoting. As you would see, in India, the RTI also started coming in way back in 1996. Tamil Nadu was the first state to get it. But the present RTI, the movement which we say that what gave birth to RTI is actually, this is an organization called Mazdoor Kisan Shakti Sangathan in Rajasthan Bewar. Now they had taken out an agitation against the local SDMs and all, where they wanted the information with regard to the expenditure made by the government through contractor and through the government with regard to the infrastructure, well, and everything in that area, which was not being provided to them. Now, this simple movement definitely took a massive form. Definitely, just when these rural background people started coming to Bewar and sat down on that 40-day dharna there for this information, and they said it's my right. It was covered then by journalists, including like Kuldeep Nayyar. In fact, Prabhas Joshi in his editorial had written this, which was a very catchy line. हम जानेंगे, हम जिएंगे. We will know, we will live, which became the title of RTI movement. The right to know is the right to life, right to live. And leaving all this now, the history part which I gave you, will straight away jump to 2005. Why we needed RTI? The major reason was twofold: transparency in the government action, and B, because of the transparency, the corruption would reduce. So this was a two prime objective by which the RTI was formulated. Now, if you see the definition, RTI says, 2F says what is information. And if you read the definition, it is very wide worded. Means anything and everything can come under RTI, like records, documents, memos, emails, opinions, etc. Now, mark the word etc. Etc. is a usdom generis. Means it has to be read in context what with all the previous things. Means any information available. And definitely with the CIC and Supreme Court's interference, this information has been extended to every form of information available, subject to and except an exception provided under Section 8 of the said Act. Now, second is the public authority, which is 2H. Now, it was initially, what is public authority? Public authority means body, institution of a self-government established by or under law of Constitution of India. Now, this was primarily that it's a body, authority, or institution of self-government. Okay. So it had a restricted meaning, but it attained a very wide dimension. And one of the major cases in this was BCI's case. Now, one person, lady called Gita, she filed an RTI saying that Team India, Cricket Team India, plays for India or BCCI, which is a private body. Now, this led to this case where definitely BCCI rejected it, CPIO rejected it, saying that BCCI is a private authority. But finally, Delhi High Court said no, it is discharging public function and enlarging the scope of public authority, said BCCI is a public authority. Now, what is right to information? We had information. We read public document, public authority. Then what is right to information? Right to information means I have a right to inspect all the information. I have a right to take notes extract or certified copy permissions. I have a right to take the certified copy, including I have a right to information in form of a copies, videos in any format. So I can seek the information in any form and any manner the way I like. From only looking at it to have a visual copy of it to have a digital copy of it. Now, to get that, first thing what they needed was when you create a right to information you have created. Now, you know one thing, India is not organized. We were not there, a matured system. So, first thing was created was Section 4. Maintain the records. So they said maintain all records duly catalogued and indexed. Record would be appropriate, computerized in every form, and publish them in 120 days of the enactment. Now this is important. So the first thing and foremost thing was to create maintain the record in an archived form, chronological form, digital form, whichever manner. But the idea is that it should become easily accessible. And that was the most important thing. And which also contained not only the documents, it also contained the particulars of the organization, functions, duties, powers and duty of its officers and its employees, procedure laid down in decision making procedure. Now this is very important. Decision procedure followed in decision making procedure. We all would have heard the case of Captain Satish Sharma and state larges like petrol pump and gas cylinder agencies were being doled out earlier time because there was no transparency. So the procedure and the decision making process to be not only formulated but publicized, it became very, very important tool to curb corruption. Will stop ever. Corruption is as old as our society and civilization and it will remain forever. But apparent and blatant corruption would stop. So that is Section 4. Now, if you see Section 4 and come to thereafter, once you have all the information at a place, then what happens? I now have collected the information as a government. But then how I'll decimate it, how I'll give it to you people. So what the government created was Cpio, Spio, which is called Central Public Information Officer or State Public Information Officer. That is the starting point. This is the authority or an officer which is identified in every department, in every part of the country, who is authorized to give you the information under RTI. Cpio or Spio. Now, what is the duties and responsibilities of the Cpio? First is that he will receive your application. Okay. Now, when you see application, it can be application which can be oral also. So the Cpio or PIO's right is also duty is to help the person to crystallize the oral application into a written format. So Cpio, what he will do? A, he will get your applications. B, he will put the application in the necessary register, note it down, and archive it. Thereafter, he will proceed to the next stage, which is your Section 6. Section 6 is important, which is the request. So once the authority is created, which is Cpio or Spio, then what do? Now we have the information at a place. Now we have authority in the place. Now how do we go ahead? So created Section 6. Section 6 deals with what? Request of obtaining information. So, what you'll do? You'll make a request. Any person, any citizen of this country can make a request in writing or through electronic means, in English or Hindi or local official language. Attach the prescribed fee and send it to the authority concerned. The authority concerned is who? The CPIO. Now, this authority concerned, what he has to do is, once he has the application of yours, then he has a mandate to follow, which is Section 7. The CPIO or SPIO shall, within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject it for the reasons to be recorded specified in Section 8 and Section 9. So he has only option is to accept or refuse. Refusal only when it is barred under Section 8 and Section 9. Section 9 talks about copyright. We will deal with it. Section 8 is more extensive. We'll come to that. But important is here that once the application has been received by the CPIO, this I had told you in the CPI's duty also, but I'll just repeat it here, that what he has to do is to scrutinize the application, he has to put it in register, issue an acknowledgement to you, intimate that yes, I have received it. Next, if he has to inform you also that he will disseminate the information within 30 days and maintain the entire archive of your application till the date it is registered, so that it can be used for future reference in case of appeal. Now, when I said Section 7 is 7 and I said 30 days, it also postulates that, in case of emergency where life and liberty of the person is involved, then you have to provide the information in 48 hours. So, when you say an application, it's not that you get it free. You have to pay the fee, unless until you fall in a BPL category, below poverty lines. And the CPIO has to inform you the cost or charges, that how much money you need to pay for the information you are seeking. And you have to pay that money before the CPIO is under obligation to give you the document. If you don't pay, CPIO can refuse you the information. So as you can see, Section 4, we have to first maintain the record. Section 5 will create the authority. Section 6, we will make the application. Section 7, the authority will accept or reject the information. And inbuilt it is that if the authority CPIO is accepting your application to give the information, but you need to pay additional court fees, then you'll have to pay the additional court fees. Or rather stamp duty, it is in postal order, it's not court fees. Typical lawyers lingo I'm using court fees. So, if he accepts and gives, it's fine. Then it's easy, you have got the information, whatever you desired. But if he rejects, then what he has to do? A, he has to send you a communication in writing. B, he has to give the reason for rejection. 3, he has to provide you the time period of appeal against such rejection. And lastly, he also has to give you who is the appellate authority. So, the CPIO has to give a reasoned order. No, why reasoned order? Because way back in 1975, I remember A.K. Kripak's judgment said very clearly that whether judicial authority or quasi-judicial authority has to give reasoned order, because how the appellate authority will appreciate what went in the mind of that authority. So you have to give a reasoned order. So he has to give reason. But not only reason, he has to also indicate who is the appellate authority, what is the right, what is the period of appeal, and everything. So that you as a citizen or I as a citizen are not left in dark. That where now I have to go. Which office door I have to knock. There's another thing, that if he does not give you this information in 30 days, that means it's a deemed refusal. And against that, you can go to appellate authority. So it's not that the CPIO can sit over your document endlessly. He has to act. If he doesn't act, then it's a deemed refusal. And mind it, when we'll read this act and we'll come to section 20, there's a penalty against the CPIO if he deliberately does not give you the information. The penalties are primarily twofold. A, that he has to pay fine from his own pocket, which is rupees 250 per day, and for every day of delay. Plus, there can be a departmental action also against him. So, deemed refusal, if the PIO has done, then he can face the consequences. So, an enormous responsibility has been created on the CPIO to act in a transparent manner, in a procedure, in the manner prescribed, as we say in India, that we follow the procedure established by law. Unlike what USA follow, Fourth Declaration, Fourth Amendment of Fourth Declaration, what we call the due process of law. So that's the difference, due process of law and procedure established by law. That's the subject topic, but I definitely dealt with in Menka Gandhi's judgment. Rajesh Pandey will tell you sometime he has read these judgments a lot. So the procedure established by law, he has to follow it. That's very important. So now comes that he can reject. But on what ground? It can't be his whims and fancy. कि मैंने सोचा तो मैंने reject कर दिया. ऐसे नहीं कर सकता. He has to act as per law. Now, Section 8 provides the exception. I will not read the entire section because it has long thing. But what is there is when it affects the sovereignty or integrity of India, what is forbidden by the court, what is considered a breach of privilege of the parliament. Now, these are the. Are you there? Am I there?
Yes.
Yes, sir.
Yes, sir. Yes.
I'm there. Huh? So, as I was saying, sovereignty of India, integrity of India, what is banned by the court, correct? Then what is intellectual property or trade secrets or a commercial confidence? That also cannot be given. But I will leave this, in this, there's another important, I'll just put 3 clauses here. There are many: fiduciary relationship, foreign government, endangering someone's life and liberty. But important is what impedes process of investigation. Mark this. This is very important. So like if it's a criminal case is going on, you may not get the FIR and the investigation report as a matter of right. It has a restriction. Then it is one of the most contested clause of this is personal information. Section 8(1)(j). And it reads like, if no relation to public authority or interest or would cause evasion to privacy unless CI, CPIO or SPIO or F authorities that satisfied that larger public interest justifies disclosure. Now this is very crucial, that public personal information may not be given, but if larger public interest is involved, then it will be provided. Like when we'll see judges case, Supreme Court cases. 1997, Supreme Court came up with this, that all the judges would disclose their assets and whatever they own. Now there was one person called Subhash Chandra, I think. He filed an RTI seeking that information, was not provided. CIC said they have to provide. Supreme Court is a public authority. This matter came up before Delhi High Court, and we had a very bright judge. Now he is in Supreme Court himself, and he said, "No, you are a public authority. Supreme Court is a public body. You are a Supreme Court is a public authority, and you are a part of the public body. So you have to provide." So here they enlarge the scope of personal information. Otherwise, I as a council, you as an individual, you're not supposed. No one is supposed to disclose. I may disclose to income tax authority, but I'm not supposed to disclose to anyone who is hearing my speech today or lecture today. I'm not supposed to disclose to anyone. Similar is the situation for you all, but that's not the situation when now Supreme Court judges are there. So information and personal information, the scopes are getting enlarged, and everything is being tested on the anvil of only one thing: will it serve larger public interest? Like one case, what happened? This was a case where the wife went to the court stating that she needs the information, financial information of her husband, stating that she needs it for the maintenance case. Now, this information, this CIC definitely said, yes, it should be provided. It was challenged and upheld, saying that she needs this for her livelihood, and so this information cannot be withheld and cannot be treated personal information. So again, the scope enlarged. But very interestingly, when I was reading this, and I said, what is the contrary if the man goes to the court and says to the RTI and says, I need the information for my wife, and the answer is negative. That if the man goes to the court and asks for the similar information, he will not get, because that's the privileged information of the wife. So little biased, but this is how the court has considered them. So now when you see we'll test some judgments later on also when we'll come to the end of the discussion, just to give you a flavor of what is section 8J I was giving you. But important is that it has diluted the impact of Official Secret Act, OSA, a 1923 Act, a draconian act. Now this act was being used for any and every form to sue any person. Look, this act was formulated, if you read section 4, 5, and 7, this was primarily against spying. And it's good against spying. But this was being misused by the authorities. So this RTI has effectively taken out the sheen from this OSA, and that's why I said it records. The provision of section 8 records that provided that even in the Official Secret Act 1923, a public authority may allow access to information if public interest in disclosure outweighs the harm of the protected interest. So important it is that even if it is barred under OSA, but still you will have to provide if you have to satisfy that it outweighs the harm to the protected interest. So everywhere we will see when you will see the entire act, it is guided by only public interest or a larger public interest, and which is the guiding principle. The shining light or the only test is that will this information serve a larger public interest? If it serves, you have to provide. Section 8 bar will not come. Now in the given situation, you have section 9, which is also a very limited thing. So it is primarily infringement of copyright, which is obviously like IPR. I don't know why they created it separately, but that's fine. It says that if a request for information involves an infringement of copyright subsisting in a person other than state, it may be rejected. Definitely copyright, I have a 60 years, so copyright I'm not supposed to provide. that I have earned. But Section 10 provides an interesting thing. Sometimes what happens is that information what I ask, maybe some part is forbidden under or barred under the Act, but other part can be given. So the court has said, severe the information, what is barred as a personal information should not be provided, but what is otherwise can be given should be provided. Now, this came handy when someone asked for official noting of the government files. Now, what happens is that whenever the government acts, they have a file in which official noting goes on. Like, a UDC will write a note, a detailed note of, say, a tender of a dam. So he'll put a detailed note, whatever it is, put it to his immediate superior body. They will write their own comment on that, whatever clarification they want, objection, affirmation, whatever. Then it keeps on going up till secretary level. Now, this is called official noting of the file. So, if you ever see a government file, it will be having two parts. Left will have the official notings, yellow pages, and right will be all the documents which is there supporting that official noting. So, this official noting was never available, was not, you would never get it. So, unless until you get this official noting, how do you know what went through the mind to do a certain act? So now this official noting, you are entitled to get under RTI. But now this official noting also can contain information of Sanjiv Sahay, maybe Prince, or Sapna or Manisha, whoever is there. So it can have information of so many other people. But government will not give me information of other people because they are their personal information. So sever it. Only give information related to Sanjiv Sahay, don't give other information. So that's how Section 1110 is important and relevant. So now once we have seen that Cpio has rejected your application for information, then where you will go? We have two stages, appellate body and then CIC. What is CIC now? CIC is Chief Information Commissioner, created under Section 12 of the Act. Now, you have only one CIC and he is supported by 10 Information Commissioners. Now, this is a very, very powerful and protected body. CIC and the Information Commissioners are appointed by the President of India. They are administered the oath by the President of India. So they are powerful body. I'm not giving what are the qualifications because it can be anyone. It's not that a particular trained person or a judge has to be the CIC. It can be anyone. Any person can be CIC, but a member of parliament or a legislative assembly cannot be CIC. He should not hold an office of profit or connected to any political party or carry on business or pursuing any profession. So these are bars and very important bars. Because if you have an MLA or an MP sitting as the CIC, he will always toe the line of his own party. So we don't want them to be there. We want a neutral person, an impartial person, an independent person. If the CIC is holding, similar will be the situation if he is holding an office of profit or has a business that he has his own personal interest. Now, how they will be appointed? President appoints them. But it's not that the president himself appoints them. He has to take advice. So, he has to, there's what we call is appointment committee. An appointment committee consists of chairman, leader of opposition, and one union cabinet minister to be nominated by the Prime Minister. So an important august body. Just imagine that a CBI director is appointed by Prime Minister, leader of opposition, and the Chief Justice of India, or his nominated judge. So the appointing committee is also very, very powerful. And to make it independent and neutral, the appointment, leader of opposition has been introduced. So that leader of opposition can raise objection. Definitely, we know first CIC we had was Wajahat Habibullah, and he did a tremendous job. He and then Mr. Gandhi, they did tremendous job in the CIC. And most of the judgment, like when we read that BCCI judgment, the Supreme Court judgment, you will read further. They all came from Mr. Gandhi or these people. So they actually brought it to a very, very higher level. So I'm cutting short this part. Their term, so their appointment is done, and their term is for 5 years. Very fair. And they perform their job for 5 years. Unless until they resign or they are disqualified. Now here comes very important thing. Removal of a CIC. Removal of a CIC is not very simple. You cannot remove a information commissioner or a chief information commissioner just at your whims. The president can initiate the process of removal of the CIC, but before doing so, he has to appoint a judge of the Supreme Court. Only based on his report or recommendation, a CIC or NIC can be removed. So very important safeguard has been created, a protection has been created that CIC should act independently. Because he becomes the pillar or the person who becomes the sole repository of entire information of the country. Because he is the highest authority. Remember, section 23 of the Rti Act is a bar. It says no action suit will lie in any court. So we needed a person who is not only independent, but remains independent. So how do we do it? We ensure that the process of appointment is such that we have views of all dispensation. And the removal also does not be so easy that the government decides and tells the president. We all know that in India, what the president do. Most of the president becomes the puppet in the hand of the government, ruling government. And they do whatever the government says. It is not that we are looking at the president which was there in Rajendra Prasad or Sarvapalli Radhakrishnan or things like that. It's not that. We have the president who becomes a rubber stamp by now. So it is important that the president only will act as the recommendation of the Supreme Court judge. Now, replica of the CIC is SIC, State Information Commissioner, which is you find in section 15. Now, SIC is again the committee of appointment remains the same, but here it becomes the governor will appoint on the recommendation of the committee consisting of chief minister, leader of opposition of the legislative assembly, and one cabinet minister nominated by. And here also, if you see, the same section 17 provides the removal of SIC, and he is also protected in the same manner. In this case, the governor requests the Supreme Court to conduct an inquiry. So what it says is that CIC remains market. Such kind of qualification is not there for your Cpio. But CIC and SIC and Information Commissioner and State Information Commissioner, they have made sure that they remain independent and insulated from the normal politicking of the country. So once you have the SIC and CIC in place, then what they do? What they do is Section 19, appeal. Any person who does not receive any decision within the specified period of time or is aggrieved by the decision of the CPIO or SPIO can within 30 days prefer an appeal. Now here, when we say that what can be the grounds for appeal? A, definitely refuse to give information. We all agree that, okay, fine. B, furnished information in time. It's not only that you refuse, you have given information, but you have not given in time. 3, malafidely denied the request or give an incorrect or incomplete information. It in fact says incorrect, incomplete, or misleading information. Or it also says distorted information of the subject matter. In fact, it goes on to say, and if the CPIO has obstructed in giving the information. So these are the...
Please mute yourself, mute your mic. Mr. Bharat, please mute your mic.
So we have seen this 7 grounds on which an appeal can lie. But remember, this 7 ground is not the only 7 ground. It is just illustrative. It includes this ground. If you read the section, it is all expansive. If I permit me to just read the opening line of this section, and you'll get a flavor of what they say. So if you see, and to ensure, like it's very, very clearly it opens up. Who has been unable to submit the request to CPIO or SPIO, either such officer who has been appointed or so and so. So that is one part. Then who has refused to access to the information requested under this act, not been given the response to request to the information, who has been required to pay the amount, and so on and so forth. And for this purpose, it's very important. It says that they have been vested with the power of the civil court. And when the moment you say vested with the power of the civil court, then you know they have a power to summon, they have a power to inquire for discovery, interrogation, interrogatories, asking for documents, receiving evidence by way of affidavit, requisitioning public authorities and records, and issuing summons for examination. So they have been given complete power. And not only this, anything inconsistent with the act of the parliament and so and so, the CIC or the SIC, as the case may be, during the inquiry of any complaint under this act, examine any record which
Amar Tiwari Jindabad.
What happened?
Amar, please mute yourself.
सुन करिए, छुट्टी दीजिए, घर जाएंगे हम.
अमर, म्यूट कीजिए अपने आप को. ठीक.
So it has been given extensive power, as I was telling you, and complete freedom to act, including, as I said, that they also have a power of a court to inquire and proceed, as we say in trial, that you will summon the record, discovery, interrogatories, record the evidence, get the documents examined, summon any witness to give evidence on affidavit, and so on and so forth. And beyond that, so that is one part. That becomes adjudicatory. As an appellate authority, you decide the appeal. But second part becomes very important, which I was connecting to section 5. That when the CIC or SIC comes to the conclusion that the action of CPIO was not in accordance or consonance with the Act, then he becomes personally liable, where cost can be imposed upon him, which is, as I said, 250 rupees per day, maximum to 25,000, or there can be a disciplinary action against him. An very interesting judgment happened in this case was this. Arvind Kumar Lohani. Now, he was one of the CPIO who was burdened with cost. So, he filed a writ petition in the High Court, challenging the cost. Fair enough, that cost was challenged by him. But what the court opined was very important. That the CPIO who has been punished under this act, he can come to the court only in his individual capacity and not by the government. Secondly,
चल खत्म कर
क्या है भाई? Who is this person?
अमर
सर रिमूव कर दीजिए ऐसे सर।
खत्म कर कोई कुछ नहीं बोलेगा खत्म कर डायरेक्ट अब
अमर न्यूसेंस कीजिएगा तो आपको प्रॉब्लम होगा बाद में। ये बेसिक चीज सीख लीजिए। सॉरी
True, if you're not interested, you can go out. Let other people listen. So, the court said that he has to come in his individual capacity. He has to engage a private. So another judgment came on this aspect was that, section 23 is a bar, which says that no suit or proceeding will lie. So then what happens? Does the CPIO or CIC order becomes final and binding? Now this issue we have dealt in many other revenue cases and all, where like in revenue cases, Delhi Land Reforms Act, or UP Zamindari Act, same Zamindari Abolition Act you had in Bihar and Jharkhand also. So all these acts where the civil proceeding is barred, they say writ proceeding is maintainable. And the primary judgment, which is that Hari Vishnu Kamath's judgment, which is the 1955 Supreme Court, which says writ of certiorari is maintainable. So invoking that parameter, in these cases also, like in RTI, they said no, against the order of the CIC, a writ is maintainable. And definitely writ jurisdiction, as you would know, there will be error of judgment. The tribunal or court has acted illegally, or they have not followed the principle of justice, as you see, order patham and all. But importantly, what they say is that in writ of certiorari, the court acts as a supervisory body and not appellate body. But these are the 4 or 5 criteria where the High Court can interfere against the order passed by the CIC. And that's how the bar of section 23 has been removed to that extent. Because you need to get it tested in the court of law if need be. So if you see the entire code, there will be only 4 or 5 sections which is relevant. Section 6. Because remember now section 4 is OTOs. Because not document informations have been assimilated from 2005 till today. And every public authority, they know that if they don't do it, they'll suffer. So informations are there now. Section 5 again has become irrelevant because every authority has a CPIO. So for us as a law student or as a lawyer, which are the sections very important? Section 6. a right to make an application. Section 7, the CPIO accepting or rejecting the information. Crucial section becomes 8, whether CPIO has rejected in terms of the mandate of Section 8 or not. So Section 6, Section 8. Then your Section 14 to 17 is not relevant so much because that primarily constitutes of appointment, tenure, qualification, and removal of CIC, SIC, and IC or SCIC, Chief Information Commissioner, State Information Commissioner. So 12 to 17 deals with that. 18 is important because it qualifies their function. Now, as a law student and for a lawyer, 19 becomes very important. 19 and 20. 19 is appeal where it lies and against what it lies. 20 is the penalty and punishment to the CPI for not acting. So if you put it, actually it will be only 3 sections which becomes relevant. 4 sections, Section 6, Section 8, Section 19, Section 20. Which is the most important section. And if you see the judgments, most of the judgments have been based on these sections only. What I'll do is, look, I've covered the Act. The Act is very small. So I've covered the Act. I'll just give you one example, 1 or 2 judgments, and then I'll leave it open for you people to ask. We have done it already. Yes. So, like, one of the judgment as a lawyer, as a student, what is important was that CBSE case, Aditya Bandyopadhyay's case. In that case, this student wanted to see his examination paper and also wanted the copy of that, certified copy of that. CBSE refused the same, citing the provision of Section 8. So this was challenged and matter went to Supreme Court. And Supreme Court said, so you have to give it. You cannot deny this information. The only qualification Supreme Court said that unless and until the examining body is able to demonstrate that the answer book falls under the exempted category. Now, what happens is some of the answer sheet can be under exempted category. We can say like, under NDA or things like that. So that we are keeping separate. That's why it has been created a qualification. But otherwise, the court said to CBSE that you will not only permit him to inspect, but he also has a right of certified copy. So that is important. In fact, the 5 judgments which I found very, very important was this definitely CBSE case, BCCI case, which I told you, which enlarged the scope of public authority. C, I told you this judgment where the court said that writ jurisdiction can lie. And I had cited you that judgment. Then your other judgment, which becomes very, very relevant, was that Supreme Court judgment, where the assets were also brought into the Supreme Court judges were also brought into the scope and ambit for disclosure. So these are the few landmark judgments which has come, and all enhancing the scope of RTI. Okay, so Rajesh, what I'll request is let's have some questions.
Yes, we can go ahead. Actually,
because once we have done this act, it's better we have some questions around.
Yes. You have given quite a long lecture on this, and the act deserved this kind of treatment, and you have done it to our benefit. So I'd request the listeners now to put any question that they might have.
Sir. Sir, if I complain to, if I file RTI to SP, he didn't respond within 30 days. So when we can file a complaint?
No, what do you mean SP?
First,
No, question is who is SP?
Superintendent of police. Yes, sir.
No, but again, it's a very wide ended question, because you will file to the authority,
Yes,
which
sir.
is the CPIO and the police department, not only to SP. Definitely, if the information is not barred under Section 8, he is supposed to provide you.
Okay,
And if he does not provide, then the appeal is the only authority which you have. Got it?
अमित, आप satisfied हैं, संतुष्ट हुए?
so sir, where can I, sir, complain first, sir, about this?
Okay.
You will find it with the, you see, if you go like, every authority will, every organization will have an authority. आपको वहां जाने की जरूरत नहीं है. आप एक काम कीजिएगा कि आप अपने लोकल पुलिस थाना पे एक एप्लीकेशन लिख दीजिए, जिसमें आप ये लिख दीजिए, टू द CPIO, पुलिस स्टेशन सो एप्लीकेशन अंडर Section 6, and you put the required information. You will get it. आपको कहीं जाने की जरूरत नहीं है. इनफैक्ट अगर आप कभी भी ये फॉर्म, अगर आप RTI एक्ट में खोलेंगे ना, उसमें फॉर्म A बड़ा क्लियरली लिखा हुआ है कि what all you have to write. And the moment you write, the public information officer, you don't have to write a person's name. This is an authority and a designation itself. समझ गया बात को?
Yes, sir. Thank you, sir.
सर, यदि सेकेंड अपील में अगर हम सेटिस्फाइड नहीं हो पाते हैं तो क्या डायरेक्ट हम हाई कोर्ट में जा सकते हैं?
सेकेंड अपील के बाद हाई कोर्ट ही एक रास्ता रह गया ना. CPIO, फर्स्ट अपील CIC, एंड देन हाई कोर्ट.
अच्छा, ओके सर.
ठीक है ना?
और जो सेकेंड
सर,
यस
सर एक
go
ये
ahead.
केस था सर. हाँ सर एक केस था गिरीश रामचंद्र देश पांडे वर्सेस CIC. तो उसके बाद सर एक ये था कि मतलब कुछ भी पर्सनल जैसे इंफॉर्मेशन है सर, वो प्रोवाइड नहीं करना है. लेकिन सर एक ये CPIO का एक केस था सर, रहमत बानो वर्सेस CPIO. तो उसमें सर वो उसमें एक डिसीजन दिया गया था कि जैसे एक वाइफ होती है और उसको अपने हस्बैंड का जैसे जो भी है वो इनकम या कुछ जानना है, सैलरी, तो वो सर वो मतलब वो जान मतलब उसको सर ये अलाउड है कि वो जान सकती है, क्योंकि उसमें कुछ ऐसा डिसीजन आया था, क्योंकि वो वाइफ थर्ड पार्टी नहीं होती है.
देखो, अगर आप एक्चुअली गिरीश जो रामचंद्र देश पांडे की जजमेंट अगर आप पढ़ोगे ना,
Yes, sir.
वो judgment was on a completely different light. It was, if I am right with my knowledge, by memory, it was they asked details of the salary, appointment, seniority, disciplinary action against all the officers. And I think it was the Provident Fund Commissioner or something like that.
Yes,
So the court said that these informations are barred under Section 8(1)(j). Because you don't have to know what is the departmental inquiry is being conducted against a person A, or what is the salary of person A, or what is the seniority of person A, unless until you show very, very large public interest. So Deshpande's judgment was actually, when they gave 8(1)(j), it was with that perspective. Then you cannot ask for a omnibus information without a basis or a reason.
yes, sir.
ठीक है ना? और जहां तक आपकी जो बात है, वो जजमेंट इनफैक्ट मैंने आपको when I was making my opening lecture, when I came to Section 8, I told you this कि भाई ये anomaly है कि when the wife asks for information, she will get it, which you rightly quoted very nice of you, Rahmat Bano,
Yes,
that
sir.
she will get it, but a husband will not get it, which was actually Pawan Kumar Saluja's case. Okay.
Yes.
Sir,
Yes, Pratyush.
sir, as we know, sir, that under the RTI only we can ask for the information about public bodies. But is there any provision under which we can ask ask about private companies also? Is there any law or body like that?
No, it's not under RTI.
Okay, sir.
It doesn't fall under RTI.
Hello, sir.
Unless
Good
until
evening.
it's the public authority, public organization.
Hello, good evening, sir.
Okay, sir. Thank you.
Good evening.
Good evening, sir. This is Shobhajit Chakravarti,
Yes.
Assistant Professor of Law, University Law College.
Yes, Shubha.
Sir, there is a
Okay, okay. Yes.
sir, there is a serious concern about public listed company. I mean, the companies which are playing with the sentiments of the investors. Investors are investing in mutual funds. Investors are investing in public listed companies for shares. Now, the thing is that if some investor wants any query from a public listed company, it is not falling under the RTI Act. This is a serious lacuna, I think, sir.
According to me, again, this can be an issue. Definitely, if you don't have the information and if the company is acting, you have definitely remedy under SEBI, and lot of remedies are provided. So I'm leaving that part completely.
Okay.
So that it's not that you are remediless against a non-action or a deliberate action of a private company. Okay. So
Thank you, sir.
SEBI has an ombudsman where you can file your complaint and they will decide it. But definitely RTI has still not been enlarged. As we say, that public authority had a restrictive meaning. And when we saw this judgment of BCCI coming in, which was that Gita's judgment, there they have increased enlarged the scope of public authority, where the public interest and other factors started playing in with the court. Okay.
Yes. Thank you, sir. Thank you, sir. Thank
Okay, Shubhaji. So nice to talk to you. Yes, we can have another question.
सर आरटीआई को पीएमओ के बाहर तो नहीं रखा गया, अभी संशोधन उसमें किया गया, तो पीएमओ अपने हिसाब से कुछ नहीं कर सकती है, उसमें दखल नहीं दे सकती है क्या?
किस चीज पे दखल नहीं दे सकती है?
या किसी इंफॉर्मेशन को दबा सकती है?
देखो, पीएमओ has a multiple function. We cannot just say कि पीएमओ इंफॉर्मेशन दबा सकती है. इंफॉर्मेशन तो अब कोई नहीं दबा सकता है अंडर आरटीआई इफ इट इज परमिसिबल. बट पीएमओ ऐसा नहीं है कि केवल एक जॉब कर रहा है. पीएमओ which also includes appointments. So पीएमओ की जो भी इंफॉर्मेशन है, if it is not falling under the bar of section 8123, what we said, sovereignty, integrity, or breach of parliamentary privilege, or a state legislature, or as we say, your foreign relations, अगर आप उनको छोड़ दें, तो yes, you have to provide the information. आप दबा नहीं सकते हो. दबाना is definitely illegal.
और प्रश्न है कुछ लोगों को? Anyone else?
Yes, sir. Yes, sir.
Okay, Ruhi.
Good evening, sir. I'm Ruhi from Jamshedpur Law College. I wanted to ask you, sir, that why don't public authorities suo moto disclose the information to the public? This will save so much of time and it will maintain transparency in governance also. And it will save the taxpayers' money, and people won't have to run around the bush, and all those penalty things, they will be curtailed. So why don't they just mention it in the website, be clear and transparent from the very first step?
So actually your questions is answered in section 4. Obligation of the public authority. Maintain record duly catalogued and indexed. Okay. And then they say publish it. So what you are saying is definitely published. But remember, every and any information cannot be published. Now the government authority has an official noting file. They cannot publish it. It can contain a personal information of some people. That person will have a right to object to that information being disclosed under section 8. So you cannot publish everything under the sun. But definitely you have to publish everything what is under the section 4. and they are under obligation to do. But
I agree,
everyone,
sir. But whatever is written in Section 4, the public authorities don't even publish that bit of information.
that
And
is
the Supreme,
that is
yes.
incorrect. Look, if some authority is acting against the mandate of law, then what option as a citizen we have to bring to the knowledge of the appellate authority? If they also don't act, then bring it to the knowledge of the court. There's no other way. If someone doesn't act, we cannot hang that person. We have a legal remedy only. However aggrieved we may be or agitated we may be. You are right that many authorities were not doing it, and still they are not putting all the information. But if you see what was there in pre 2005 and you see what is there in 2022, you will realize quantum leap has been taken by the authorities in providing the information. In fact, I am arguing a case where in Delhi High Court, where I am based the entire thing. They rejected an allotment of a shop to my client. So they had closed down in Delhi. There is a place called Daryaganj where is the full mandis. Now that mandi was closed and they was shifted to Okhla Sabji Mandi. So now in Okhla Sabji Mandi there was allotment of shops. Now this shops became very premium because understanding APMC, all the vegetables and granaries they come only in APMC market. So the Okhla Mandi became very, very cash cow for everyone. So my client was denied shop because they must have taken money from someone else and given it to them. So under RTI, I told him to take out all the information. And my client was the last person to get information. After that, they burned the record. So now today, if someone makes an application, it is burned. But because we got the entire information, so we said that what the reason for rejection, what they have recorded, is incorrect.
Okay,
So
sir, this is
that's the only way
very...
to act. Yes, sir.
Nowadays, yeah, you were correct when you said that when it is in paper form, they burn it. Even in the Coal India scam, what happened? They said we don't have the files, we don't have the documents, so we can't help the court. But then now everything is getting digitized. So it will be easier to say that I did an all control delete, everything is vanished. So the very essence, the very soul of RTI will be hampered if this deletion and burning goes on.
No, that is a much larger issue, Ruhi. We cannot, that cannot be answered. Like as I say, very simple example. We all know to murder anyone is a crime. Whether you're a law student or an average ordinary citizen, it's a crime, but still people do it. So we cannot stop the crime. Civilization is there, crime will remain, and crime will have another remedy.
Okay, thanks, sir.
Good evening, sir.
Good evening.
Yes, sir. My question is, what is the fee paid by an Indian national to file a first appeal?
You are the only
Sir.
person who was disturbing the talk process?
Yes,
Amit?
sir. Yes, sir.
Who was the Amit Rajesh Pandey who was disturbing the talk during the
No,
talk?
no,
Was
he has been removed. He has been removed.
He has been removed. Okay. Okay.
Yes.
So, the fee will be prescribed. It is a prescribed form.
Yes, sir.
Offhand, I will not be able to give you what is the amount exactly, because if the Section 7 rejects it, under Section 7, if the CPIO rejects it, he has to also inform you what is the fee to be paid. So he has to inform you 4 things: reason for rejection, the appellate authority, who is he, the period of limitation, and what is the fee to be paid.
Yes,
Okay.
sir. Thank you, sir.
Okay.
सर मैंने एक अपील किया था, सेकेंड अपील। उसमें सर्वेक्षण कॉपी मांग किया था हमने आंगनबाड़ी सेविका से, और तो उनके बिहाफ में सीडीपीओ जो है कि सेकेंड अपील में वहां पे प्रेजेंट होती है। तो क्या मैं कुछ गड़बड़ हो जाती है उसमें, वहाँ पे अदालत में हम प्रेयर कर सकते हैं कि जो आंगनबाड़ी सेविका हैं उनको यहाँ पे किसी माध्यम से बुलाया जाए, तो ऐसा कोई प्रोसेस है वहाँ अपील में?
एक मिनट, थोड़ा सा क्वेश्चन को फिर से आप बताओगे क्या आप बता रहे थे?
ये सर जैसे मैंने सर्वेक्षण कॉपी मांग किया था आंगनबाड़ी सेविका से, तो उन्होंने
आपको नहीं दिया गया?
हाँ, हमको नहीं दिया गया। तो मैंने फर्स्ट अपील फिर सेकेंड अपील में गया, तो सेकेंड अपील में जो कि वहाँ पे जो बुलाया जाता है तो सीडीपीओ मैम जाती है वहाँ पे, जो प्रखंड से होती है। तो वो जो है कि सेटिस्फाइड, उनका मतलब डॉक्यूमेंट से जो भी कॉपी मिलता है तो उससे हम सेटिस्फाइड नहीं हो पाते हैं। तो उसका हम जांच के लिए हम जैसे वहाँ पे क्या प्रेयर ऐसा कर सकते हैं कि जो आंगनबाड़ी सेविका है उनको यहाँ पे बुलाया जाए और जो भी डॉक्यूमेंट है यहाँ पे आप अपने खुद से उसका देख सकते हैं?
आप एकदम बुला सकते हो। मैंने जब आपको सेक्शन 18 पढ़ रहा था, जब डिस्कस कर रहा था, उसमें आपको बताया था कि the appellate authority, they have a power of a civil court. उनके पास सिविल कोर्ट की पावर है, जो हिंदी में दीवानी कोर्ट कहते हैं हम लोग शायद, उसका पावर है। तो वो किसी को भी बुला सकते हैं, किसी को भी समन कर सकते हैं, किसी को भी कह सकते हैं कि आप रिपोर्ट प्रोड्यूस करें। तो आप ये रिक्वेस्ट और प्रेयर सेक्शन 18 के तहत आप कर सकते हैं appellate अथॉरिटी के पास।
तो उसका प्रोसेस समन के द्वारा ही होगा ना सर?
हाँ, वो appellate अथॉरिटी करेंगे।
अच्छा,
वो खुद समन उनको भेजेंगे, वो चाहे आपके थ्रू भेजे या खुद अपने से भेजे।
ओके सर, थैंक यू।
सर
ओके राजेश, आई थिंक वी हैव कंप्लीटेड इट सीम्स।
एक और व्यक्ति कोई पूछ रहे थे कुछ।
सर लास्ट क्वेश्चन सर सर्टिफाइड कॉपीज के बारे में आपने बोला था सर उस टाइम कि सीबीएसई से मांगा गया था तो वो तो लास्ट में दे दिए, बट एनडीए वगैरह अगर से मांगा जाता तो वो लोग नहीं देते हैं सर। जैसा अब एग्जाम्स में सर कुछ गड़बड़ी देखे जेपीएससी वगैरह का सर, तो ये सब से हम लोग ले सकते हैं कि नहीं? अगर हम लोग
जेपीएससी से मैं आया दैट, देखो हमने तो जब डीएनबी का केस किया था इन मेडिकल, तो वी हैड आस्क्ड देम टू गिव अस द कॉपी एंड कॉपी वाज शोन टू अस। तो ऐसा नहीं है कि आपको रोका जा सकता है जहां पर आपको लगेगा कि ये है, बट अब पर्टिकुलरली जेपीएससी इज द कॉम्पिटिटिव बॉडी,
यस सर,
उसको एक बार टेस्ट करना पड़ेगा। बट आई कैन टेल यू दिस कि बिकॉज ऑफ दिस जजमेंट ऑफ सीबीएसई, according to me, this examination paper of your only, आप सबका नहीं मांग सकते, तो आपका अवेलेबल हो।
यस सर,
एकदम होना चाहिए, इसमें कोई प्रॉब्लम नहीं है।
ओके सर, थैंक यू सर।
ओके,
गुड इवनिंग सर।
गुड इवनिंग
सर एक लास्ट क्वेश्चन सर क्लियर कर दीजिए थोड़ा सा। जैसे अगर सर कोई प्राइवेट बॉडी है, लिमिटेड प्राइवेट बॉडी है, लिमिटेड प्राइवेट बॉडी के अंडर पे अगर कोई आउटसोर्स काम करता है, तो आउटसोर्स अगर काम करता है सर, तो आउटसोर्स में जो भी एम्प्लॉयर एक एम्प्लॉय को हायर करता है, ठीक है, एम्प्लॉय अगर कोई भी इंफॉर्मेशन लेता है उसके एचआर से, अगर वो नहीं देता है तो हम डीएलसी जाते हैं सर, डिस्ट्रिक्ट लेवल कोर्ट। तो डीएलसी अगर जाते हैं सर, डीएलसी अगर हमको सेटिस्फाइड नहीं करती है तो उसके लिए आरटीआई फाइल कर सकते हैं उस प्राइवेट कंपनी जिसके अंडरटेकिंग में आउटसोर्स काम कर रहा है।
प्राइवेट कंपनी इज नॉट अंडर आरटीआई। आप लेबर कोर्ट जा सकते हो, डिस्ट्रिक्ट लेबर कोर्ट चले जाओ, आप उसके अगेंस्ट नहीं होता है तो आप हाई कोर्ट में चले जाओ, रिट में चले जाओ, 227 अपील में चले जाओ, आपका अपना रेमेडी है उसका। ये तो नहीं है कि लेबर कोर्ट नहीं आपको देता है तो आपके पास ऑप्शन नहीं है। आपको लेबर कमिश्नर के बाद लेबर ट्राइब्यूनल है, लेबर ट्राइब्यूनल के बाद हाई कोर्ट है। द एंटायर मैकेनिज्म इज देयर।
रेट डाल सकते हैं उसमें ना, पिटीशन डाल के उसका आंसर तो मांग सकते हैं ना सर?
ऑब्वियसली आप अपना प्रोसेस में तो मांग ही सकते हैं। आप जब से लेबर कमिश्नर पे डालोगे या लेबर ट्राइब्यूनल पे डालोगे, वहां पर आप नोटिस टू प्रोड्यूस डाल दोगे अंडर ऑर्डर 11 ऑफ द सीपीसी। उसको सब इंफॉर्मेशन लेके आना पड़ेगा व्हिच इज इन हिज पावर इन पोजीशन।
मैं सर सीपीआईओ और सीआईसी सेम है?
सीआईसी और सीपीआईओ में ट्रायल कोर्ट और सुप्रीम कोर्ट वाला डिफरेंस है।
ओके सर।
CPIO is the first authority and CIC is the last authority.
ओके सर। सर उसके बाद फिर सुप्रीम कोर्ट जा सकते हैं?
उसके बाद हाई कोर्ट, देन सुप्रीम कोर्ट।
ओके सर।
ठीक है।
मेरे ख्याल से काफी लंबा सेशन हो गया है और अब हमें लगता है कि अब संजीव जी को थोड़ा आराम करने दें और हम लोग
सर वन मोर लास्ट क्वेश्चन सर।
संजीव जी आप लेंगे
सर?
चलो एक लास्ट क्वेश्चन करके साथ खत्म कर देते हैं।
ओके।
Hi sir, this is Rohit Mukherjee from Jamshedpur Cooperative Law College sir. Sir, I wanted to ask how many questions we can ask in a single RTI and what are the requisites for accomplishing an RTI sir?
देखो पहले लिमिटेशन था, but then there was a famous judgment. This judgment came of I think Bambari or something like that, and after that these all restrictions of word limits and all has been removed. So now there's no such restriction कि आप क्या मांग सकते हो। पहले restriction definitely थी, but अब वो restriction नहीं रह गई है। ठीक है ना? You can ask any information.
And requisites sir for accomplishing an RTI?
Requisite सिर्फ एक है, you'll have to pay the fees, whatever be the DD, and you'll have to pay for it. वो तो है नहीं ना कि आपको free देगा वो, unless until a person falls under BPL. You have to go there and ask for the information. You'll have to, the Cpio will tell you what is the fees to be paid. You pay the fee and they will provide you.
Okay sir.
If I'm not mistaken, it was Vishwas.
Thank you sir.
Vishwas's judgment, I think.
Sanjeev, I have a request from one Neeraj Kumar.
Okay.
He is pursuing that he wants to ask a question. नीरज
Okay.
आप सुन रहे हैं हमारी बात? नीरज आप सुन रहे हैं हमारी बात? नीरज आप सुन रहे हैं हमारी बात? एक मैसेज आया था।
अच्छा।
लगता है हम उन्हें रीच नहीं कर पा रहे।
ओके।
सर मैसेज मैंने ही डाला था कि सीपीआई और सीआईसी सेम है क्या?
अच्छा। Okay. So that has been answered.
Okay. So सुभाजीत आप कुछ बोलना चाह रहे थे मेरे ख्याल से?
No, sir. I have discussed the point. It was really a wonderful lecture, wonderful session. Thank you, sir. Thank you for your wonderful knowledge. Thank you, sir.
So nice. Coming from the professor, I take it as a compliment.
Thank you, sir. Thank you, sir.
Okay.
Actually, we should be very grateful because he is sparing his very valuable time only to guide the law students and the newly enrolled lawyers of Jharkhand. Because ये समय है इनके client conference का, इनके cases को discuss करने का, और बहुत सारे family commitments होते हैं, उन सब चीज़ों को छोड़ करके और संजीव जी आते हैं और यहाँ पे मार्गदर्शन करते हैं हमारा। We should be very deeply obliged to him, and we would definitely request him to come again and be a regular speaker on our platform. जो भी आप लोगों को कुछ कहना हो तो आप लोग जरूर हमें मैसेज कर दीजिएगा तो हम संजीव जी को फॉरवर्ड कर देंगे। Thank you so much, Sanjeev.
Okay.
Thank you so much, sir.
So nice.
Thank you, sir.
Thank you sir.
Okay.
Thank you, sir.
Thank you, sir.
Very many thank you.
Thank you, sir.
Thank you, sir.
Bye. Good night.
Good night, sir.
Good night, sir.
Good night, sir.
Good night, everyone.